Rolando de la Cruz of Sampaloc, Manila sent us an email. According to Rolando, they have a neighbor who has been complaining regarding Rolando's gate that allegedly bars their way of right or right of way. However, according to Rolando, his neighbors have no cause to complain because the latter has no other access to the road, or because the latter has another access to the road. Because of his neighbors' incessant complaints, Rolando wants to know what are the limitations to a right of way. Can his neighbors have more than one right of way? Rolando, your neighbor insist on another right of way when he or she has another adequate outlet to the main road. In the case of Dichoso versus Marcos, GR number 180282, April 11, 2011, the Supreme Court cited Article 649 of the Civil Code, which states in part, the owner or any person who, by virtue of a real right, may cultivate or use any immovable which is surrounded by other immovables pertaining to other persons and without adequate outlet to a public highway, is entitled to demand a right of way through the states after payment of the proper indemnity. Should this easement be established in such a manner that its use may be continuous for all the needs of the dominant estate, establishing a permanent passage, the indemnity shall consist of the value of the land occupied and the amount of the damage caused to the servient estate. To be entitled to an easement of right-of-way, the following requisites must be met. First, the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway. Second, there is payment of proper indemnity. Third, the isolation is not due to the acts of the proprietor of the dominant estate. And fourth, the right-of-way claimed is at the point least prejudicial to the servient estate, and insofar as consistent with the rule, where the distance from the dominant estate to a public highway may be the shortest. Remember, though, the well-entrenched doctrine that in order to justify the imposition of an easement of right-of-way, there must be a real, not fictitious or artificial necessity for it. Mere convenience for the dominant estate is not what is required by law as the basis of setting up a compulsory easement. Even in the face of necessity, if it can be satisfied without imposing the easement, the same should not be imposed. Be reminded that our opinion is based solely on the information you provided us, and it may change depending on any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at ptv4newscenter@gmail.com. Attorney Jimeno Atienza for the Rule of Law.